Okay, so types of law, chapter 3. So what is the meaning of law? All right, I need you to move. I don't know if y'all can see it, but it's, let me see if I can get that off. There we go. It is a custom or practice of a community. It is a rule of conduct or action prescribed or formally recognized as enforceable by a controlling authority. So if you didn't know the exact meaning of law, there you go. It's in our book. I got it straight from our book. Okay, so we have different branches of law. Legislative, which leads to Congress, the House of Representatives, and the Senate. Then we have executive, which is the president and the vice president. And then judicial, which is the Supreme Court. So I felt like this really was a good visual for you guys. I'm a visual learner myself, and I read all of that in the book, and I said, boy, I didn't remember any of that. So I went out and found something that we could kind of look at and see, and then I was like, oh yeah, now I understand what it meant. But I had to have this visual instead of all of those words. Okay, there are lots of kinds of law, but we're going to be focusing on two main categories right now, which is, well, I want to point out that we have criminal law, contract law. Contract law can have something to do with medical, administrative law, and tort law, human rights laws. Some of these have to do with medical and some do not, but we're going to kind of hit those that do have stuff to do with healthcare. Sorry, my kids slammed the door and it got me all thrown off, y'all. Okay, so criminal and civil law is what we're going to talk about first. Laws can be divided into two main categories: substantive laws that determine rights and obligations of people derived from common law and statutes, and then procedural law, which are laws that all parties must follow when investigating and prosecuting unlawful acts. Let's talk about criminal law. Criminal law, statutes that define actions or omissions that threaten and or harm public safety and welfare. I think we all pretty much know what criminals are, but you know, this is kind of breaking it down in the more formal verbiage. It's a punishable offense by the state and federal government. Misdemeanors are minor crimes, but there is also felony and treasons, which are major crimes. Let's talk a little bit about civil law. Civil law protect and define private rights, not criminal in nature. It's usually with individuals, organizations, and government agencies. Many branches of civil law include tort law, contract law, property law, and family law. So have you guys ever heard of like civil court? Judge Judy is a civil court. The people's court is a civil court. It's not, you know, it's not major court. It's not like criminal. Which types of civil law directly affect the medical profession? Tort law, contract law, and administrative law. Those are the three that directly affect the medical profession. So let's talk about tort laws. Tort law enforces rules that we have in our society. There are two types of torts: intentional and unintentional, or negligent. With an intentional tort, the plaintiff must prove the defendant had specific intent to perform the action that caused the injury. So common intentional torts include assault, battery, false imprisonment, fraud, defamation, and invasion of privacy. So negligent torts, negligent acts can be classified as malfeasance. Okay, these are two, you guys need to know these. Malfeasance is performance of unlawful, wrongful act. Misfeasance is an improper performance of a lawful act. Nonfeasance is failure to act when one had a legal duty to act, and malpractice is the type of negligence that applies to professionals. Negligent torts are more common in healthcare because they are unintentional. So we're going to talk about standard of care and scope of practice. So standard of care takes into account the accused person's skills and knowledge, also considers the environment. Medical assistants need to be aware of standard of care. If a medical assistant's practice beyond their scope of practice, they may be held to a higher standard of care. So we talked a little bit about standard of care before, and I'm bringing this up again, and you're going to see it a couple of more times because it's so important as an administrative medical assistant. You're not practicing out of your scope of practice, which means you can't go give Miss Jones her injection because it's not what you're trained for. So if she got hurt and she sued the doctor and she said, oh, Melinda gave me my shot that got infected that made me lose my leg. You understand what I mean? That is completely out of your scope of practice, and you have no business doing that. And your physician has no business asking you to do that. A nurse, an office manager, anybody. You say, no, ma'am, that's out of my scope of practice and I can't do that. And I think that that makes sense. You know, I think if you think about it, if they're asking you to do something that you're not trained to do, then that's a firm, sorry, I cannot do that. Now, if they're asking you to answer the phone, well, that's absolutely in your scope of practice. If they ask you to take out the trash in the back room, it's in your scope of practice. You can take out trash in a trash can. But I'm not being silly. I'm just saying you guys really think about if you're trained to do blood pressure, then absolutely, if you're trained and you feel comfortable. We've talked about that before. So let's talk about malpractice. Everybody wonders why insurance is so expensive. Malpractice. For doctors to get insurance on their facilities is astronomical because people are sue happy, right? So let's talk about what malpractice is. It's a type of negligence in which a licensed professional fails to provide the standard of care, causing harm to the patient. It's much harder to prove than what people realize. Malpractice is very, very hard to prove. Okay, so proving malpractice turns to no. A summary judgment is a process that can be used if there are no disputes about, so sorry class, let me let Miss Peggy know, she's a new instructor, that I am on Zoom call right now. Hi. Miss Peggy, I'm in the middle of my class Zoom. Can I call you back?
Yes, thank you.
Thank you. Bye-bye. Sorry about that. So I didn't want to not answer. She wouldn't understand. So we were talking about a summary judgment and what it was. A summary judgment is a process that can be used if there are no disputes about the facts in the case. Mediation is third party, helps those involved in a dispute solve their own problems. You guys have heard like of divorce mediation and child support mediation, and let's see, mediation between neighbors, because we have a lot of that nowadays. But arbitration is alternative to a trial in which a third party is chosen to hear the evidence and make a decision about a case. So many cases, they love to try to use mediation or arbitration because it costs so much less. It doesn't cost as much money to the system. So they really do try to arbitrate and mediate as many cases as they possibly can. So proving malpractice, alternative dispute resolution, which is ADR, is the process of setting disputes outside of litigation, arbitration, and mediation. With civil litigation, either party or judge can move for a summary judgment. Okay, that was just out of the book, and part of the sentence, it went a little bit over my head, but it was there, so we read it. Okay, so we're going to talk about the 4 Ds of negligence. So the first D is duty of care. Healthcare professional has a legal obligation to the patient. Dereliction is healthcare professional breaches, violates the duty of care to the patient. Damage, patient suffers a legal recognized injury. And then direct cause, breach of duty of care directly causes the patient's injury. So those are the 4 Ds of negligence. And I know it just sounds like different information on each slide, but we're really just kind of going through the chapter. If you've read chapter 3, I'm kind of following up and just giving you the high points. Okay, so let's talk a little bit about types of damages. There are punitive damages. They were historically set so that the amounts would discourage intentional wrongdoing, misconduct, and outrageous behavior. Tort reform is currently a much discussed subject, would cap the amount of money that could be collected during a personal injury litigation, including medical malpractice cases. Punitive damages, which is things that we hear about, are set to a limited monetary value. I'm just going to go through, I'm not going to read all of them. And then their general damages include compensation for pain and suffering, for loss of bodily member or faculty, for disfigurement, or for other similar direct losses or injuries. So those are the most common types of damages. And again, came straight out of your book. So we're going to talk a little bit about liability insurance. Professional liability insurance is a type of liability coverage used by professionals to protect them against liability suits incurred because of errors and omissions while performing their professional service. Your physician, your hospitals, they all have liability insurance because accidents happen. Things are dangerous when you're getting a surgery or you're having anesthesia. You have to have that liability insurance. Medical malpractice insurance is a type of professional liability insurance that protects healthcare professionals from liability related to wrongful practice resulting in injury, expense, and property damage. So you guys get what my liability insurance is for malpractice. General liability insurance is a type of liability insurance purchased by companies. And then personal injury insurance is a type of liability coverage that protects against claims related to harm other than bodily injury. So I want to talk about a different liability insurance. How many of you just have liability on your car? If it's paid off, a lot of people cut down to liability insurance. That means if you get in an accident and it's your fault, it's only going to pay for the other person's car. It's not going to pay for you. It says you're liable. So there are lots of different kinds of liability insurance. And I just wanted to talk about one that's not listed, and that's with your car insurance. So insurance pays for different things. Insurance is the same thing all the way across the board. It just may pay for different aspects of your life. So let's talk about contracts. A contract is an agreement between two parties, and there are 5 elements to every contract. There's an offer, an acceptance, a consideration, legal subject matter, competency and capacity, and you can have an implied contract or an express contract. So let's talk a little bit about competency and capacity in a legal contract. Can you make a legal contract with an 18-year, well, let's say a 16-year-old? No, they're not legal. You cannot venture into a contract with someone unless they're of competent age. So contracts have rules and regulations of their own. Now we're going to move into chapter 4, healthcare laws. Now, I want to say that healthcare laws and ethics, which are our next 2 chapters, chapter 4 and chapter 5, are so very important. There are going to be a couple of laws in these next slides that are not in your book, but I know you need to know them. They're in your NCCT, and I'm going to make sure that you know them before you ever go take your NCCT. So let's just go ahead and get started. So let's talk about privacy and confidentiality. So privacy is being free from unwanted attention. Confidentiality is legally protected right of patients. All states have laws regarding confidentiality. If state law is stricter than federal law, it takes precedence. An invasion of privacy is the disclosing of private facts without the consent of the individual. An invasion of privacy is an intentional tort. It is a crime. So can you think of something that maybe we have set into place that that will prevent this? It's the HIPAA law, right? We have to make sure. HIPAA is big, guys. HIPAA is big. So I'm not going to read through the HIPAA privacy rule, because how many times have we went over it? 5 or 6 times now. It's noted a little bit differently in this chapter, but I'm going to leave that to y'all to read. But I didn't want to go through some acts and laws without including the HIPAA Privacy Act. So this is something that's very, 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 very important, and you need to know it. Let me see if I can move this out of the way. I don't know if y'all can see that, but I can't. Oh, see, I've already went too far. Okay. We need to talk about examples of covered entities under HIPAA. This is on your NCCT exam. So some examples are providers, which are medical doctors, nurse practitioners, physician's assistants, dentists, chiropractors, psychologists. Nursing homes are covered entities. Pharmacies are covered entities. Ambulatory care settings, clinics, health insurance companies are covered. Government insurance programs, Medicare and Medicaid, covered. HMOs, claims clearinghouses, and billing services are covered entities. Now, does that mean that your electric bill service is a covered entity? No. They're talking about that once you get your claims, whoever does your billing. Remember, I worked for a company called ACS, and it was a billing and coding company. We were a covered entity. So when they're talking about billing services, they're talking about medical billing services. I know that was silly, but I just thought I needed to bring that up. Okay, we're going to talk about the HITECH Act. Health Information Technology for Economic and Clinical Health Act. Now, I am going to tell you this because I want you to remember it. Anytime that you're given a choice with the HITECH Act, look for the word meaningful use. Anytime you see meaningful use in an answer, and I'm going to give you an example in a minute, it directly relates to the HITECH Act. It was passed in 2009. It contains provisions that increased enforcement of privacy and security of electronic transmission and health information, made business associates directly liable for compliance with HIPAA, and prohibited the sale of PHI without the patient's authorization. The key word to the HITECH Act is going to be meaningful use. Let's talk about the GINA Act, the Genetic Information Non-Discrimination Act. It became a law in 2008. Modified HIPAA, increased the protection for individuals, prohibits genetic discrimination in health coverage and employment. This is my favorite slide. Food, Drug, and the Cosmetic Act. You have food, drugs, and cosmetics. I just thought it was so cute. It became a law in 1937, and it replaced the Food and Drug Act of 1906. The FDA is responsible for safety, effectiveness, security, and quality of drugs, cosmetics, and food. Isn't it cute, Melinda? I just think it's so cute. Okay. Patient Protection and Affordable Act. Let me do that again. Patient Protection and Affordable Care Act, commonly known as the Affordable Care Act, signed into law in 2010. The goal was to provide Americans with affordable health insurance. It attempted to reform healthcare system and reduce healthcare spending, also known as Obamacare. It's not written anywhere here, but that's what it is. Let's talk about Good Samaritan laws. State laws that provide legal protection for those assisting an injured person during an emergency. The person responding must not be paid for care given, act reasonably, and not act negligibly, there we go, or recklessly. So I think we have a lot of problem with this nowadays, because a lot of times, well, there has been some things in the past where people have tried to help and have been sued because they tried to help. And so a lot of people are really cautious about helping now. How many of us help the older people on the side of the road when they have a flat tire? Or, I mean, I still do, but you know, it's not safe anymore. Let's talk about laws for end of life issues. Patient Self-Determination Act is all about laws for the end of life. Requires most healthcare institutions to inform patients of their right to make decisions, facilities policies respecting advance directives. And then we have the Uniform Determination of Death Act, the UDDA. I've never heard of these guys until I read them in the chapter, to be honest with you. They guide for state lawmakers to create their own laws that define death. The UAGA, which is the Uniform Anatomical Gift Act, and the purpose was to make organ donation easier. And the National Organ Transplant Act, which is established national registry for organ matching. So all of this has to do with, organ donation. This is our money spot, I'm going to call it. This is something you need to know. If you learn nothing else today, I want you to learn the Stark Law. It restricts physician referrals. A physician or a physician's immediate family who has a direct or indirect financial relationship with an entity that provides designated health services cannot refer patients to that entity, and the entity cannot submit a claim for services unless the financial relationship is within a Stark Law exception. A lot of words, right? I'm going to explain it, I promise. I'm going to explain it. So, a physician has a family member, let's say Dr. Cardiology brother is Dr. Gastro, and they only refer patients back and forth to each other. They don't set out any other referrals, and they're invested in each other's practices. That's against the law. You're not supposed to do that. But I'm going to give you some examples so that you can see what this law actually means when it's written. So don't give up. I know that was just kind of barely touching on it, but I'm going to give you some more information. The next one that you have to know is the anti-kickback statute, our law. Knowingly and willingly offers to pay any remuneration, including any anti-kickback, bribe, or rebate, directly or indirectly, overtly or covertly, in cash or in any kind to any person to indicate such person. Okay, again, what does that mean? The anti-kickback law prohibits trades. For example, I go in to see Dr. Cardiology and I say, hey, Dr. Cardiology, if you'll see me for free for the next 5 years, I'm going to give you my Saints season passes this year. He says, sure. They're getting a kickback for services. Does that make sense? So anytime that you see that something's being given, that's kickback. Referrals refer to Stark Law. So instead of just continuing on with words, I'm going to go ahead and give you the examples. Oh, well, I have one more slide about it. So Stark Law versus the kickback law. So Stark Law prevents physicians from referring patients to entities providing designated health services if the physician or an immediate family member has a financial relationship together. Anti-kickback prohibits offering paying, soliciting, or receiving financial incentives of items or services covered by Medicare, Medicaid, or other federal programs. I know that it just sounds like words at this point. So now we're going to get to the test your knowledge. I know poor Melinda's like, what does all of that mean? You're going to know in just a second. Hang on. Okay. Which of the following regulations prohibits a physician from referring a patient to a facility in which the physician holds a financial interest? A, B, C, or D? C, it's the Stark Law. Why? Financial interest. That's the word you're looking for, financial interest. It is Stark Law. The Stark Law prohibits a physician from referring a patient to a facility in which the physician holds a financial interest. This law was written so that physicians do not take advantage of a patient's health situation. It is to deter the physician from lying to make extra money. I know that I have the other slides, but that's the actual how the actual law is written. This is our words. I wanted you to see both. Okay, so here's our next one. A local laboratory sent a physician 2 tickets to the football game as a thank you for referring patients to its testing center. For which of the following has been violated? Which of the following has been violated? False Claim Act, Anti-Kickback Act, HIPAA, or Fraud and Abuse Act? We think B. You're right, Anti-Kickback Act. According to the Anti-Kickback Act, it is illegal for a physician to accept money or gifts such as football tickets for referring patients. This type of practice lessens the integrity of the services provided. Patients may be referred simply so that the physician receives gifts, and that is not legal. So does this kind of shed a light on what we were talking about? This is the real world, this is the real world of it for us, not just the laws written in those complicated words. This is just it in a nutshell. So one more. The HITECH Act was created to promote the use of better physician documentation, electronic claim submission, EHR, meaningful use, or written consent for medical procedures. Remember when we talked about anytime you see the HITECH Act, look for the words meaningful use. So let's see if the answer is correct. EHR, meaningful use. The HITECH Act was created to promote the use of EHR, meaningful use. The HITECH Act improves the quality of patient care by making medical records easily accessible by all physicians in a practice. These 3 multiple choice questions were straight from your NCCT exam. So the last thing we're going to talk about is compliance with public health statutes. Healthcare providers have a responsibility to report specific information to various authorities. They have to report births and deaths, specific diseases, sexually transmitted infections, specific injuries related to violence, like domestic violence or child abuse, neglect, and exploitation. Public health statutes exist in each state to help promote the health of residents. PHI can be released when required by law enforcement and for public health activities. So that was chapter 3 and 4. I told y'all it was a lot of words. But I hope you learned something. Melinda, don't get off with me. I'm gonna wrap up. You guys have a great afternoon. I'm going to be putting this in the gray area that says it has Zoom class recordings, I think is what I put it under, but don't worry, you'll be able to have it on Zoom.